Tony DeLuca was questioned. She was interrogated.
Let's try to separate using words such as interrogation and custody. Let's just focus first on custody.
Okay.
Because if you, I think, you tell me if I'm wrong. Well, you tell me, what do you have to prove in this case?
I have to prove that she's in custody, that the facts in her case added together lead up to custody.
All right, so tell me why she's in custody.
She's in custody because she was in the back of it was the middle of the night. She was in the back of the locked car.
Okay.
It was dark, and she had just swam. She was also never told that she could leave. She was never given she was never told why she was even being questioned in the middle of the night until the very end. She was questioned for a lengthy amount of time compared to the other questionings, and that is why she was in custody.
Okay, so that's your argument why she's in custody. All right, now, using night, car, dark, swam, never told she could leave, never told why she was there until the very end, lengthy compared to the others. I have your laundry list. Where's your legal case that holds, or your legal cases that support your facts to conclude she was in custody? What are you relying on?
U.S. versus Craighead and Thompson versus Gahan.
All right. And tell me why the Federal Circuit Court in Craighead is a good law.
It's a good law because the Federal Circuit is the Ninth Circuit, so it overarches California, or this part of California, so it is considered law here.
Okay, so why should I follow what Craighead says? What is it in Craighead that says your client is in custody?
It outlines the police-dominated test.
Okay, and the police-dominated test was what you said earlier, number of officers, armed, isolated, and restrained?
Yeah.
All right. Why is the number of officers in your case different, better, worse than what was in Craighead?
There were less officers. There was 8 in Craighead and 2 here. But it is still a majority, there are still more officers than there are Adrian Vegas.
So would your argument hold across the board, across the United States, that any time that police outnumber an individual, then that's going to be a factor that you can say leans toward custody?
It's not a dispositive factor, but it is a factor you have to consider.
And about armed officers, I think it's common knowledge that any officer on duty is armed. So why should that lead to being in custody if that's just normal police procedure?
Because an armed officer can affect how the person feels in a situation. So because the police-dominated test is a subjective test, you have to take into consideration how it would affect how the suspect would feel. And being confronted by an armed officer would definitely make the suspect more nervous or more likely to do whatever the police tell them and answer any question, even if they don't want to.
But the issue is, if all officers are armed, then by your argument and extending the logic, anytime 2 officers approach an individual and those officers are armed, that person is in custody. Or at least the factors weigh toward that logical conclusion. Is that what you're suggesting?
I'm not saying for every officer. I'm not for every suspect. I'm saying for Adrian Vega, that is the case. She's a high school age girl, and definitely being confronted by 2 armed men could be very intimidating.
You keep referring to high school age, which is an artful way of dodging the fact that your client is an adult. Okay, so I appreciate your artfulness, but I am reminded she's an adult, and I won't forget that. And I look at that as being magic. Okay?
She's still an adult girl. Even if she is a woman, but she still can be intimidated by 2 armed men confronting her, especially if one of those men, such as Officer Jackson, is 6'5", 250 pounds, and a former college wrestler. That is physically intimidating, and that can make you feel, that can make her feel that she has to answer whatever they say, even if she doesn't want to.
But do I look to whether she's intimidated in this totality of the circumstances test or the police-dominated test?
In the police-dominated test, you should, because it's a subjective test. So you have to consider how it would make the suspect feel.
So how do I juxtapose a subjective test into a reasonable prudent person test of the totality of circumstances?
Well, you can use either test. Or you can look at the answers of multiple tests and try to figure out which one would work the best in the situation. You have to consider all the factors you can, and look at the answers and make a logical conclusion.
What case supports your thinking that, or your argument, that because the officer is big, I think you said Jackson was 6'5" and 230 some odd pounds, is there a case that supports that position? That that's an intimidating position?
Well, the police-dominated test mentions whether restraint either by physical force or by threat. An intimidating physical presence can be seen as a threat.
Do we know where Officer Jackson is at the time? Well, let me back up. Where is your client in custody? What's your argument where she is in custody?
My client is in custody when she gets into the car or when she asks what to do, and the police basically say that she can either stay here and talk or leave and talk, and don't give her any other option.
All right, so it's that point in time that now she's now in custody when the officers give her two options: stay and talk or stay and talk.
Yeah, that's basically the point when custody first becomes apparent, and it becomes stronger as the case moves forward.
All right, so from that position, do we know where Officer Jackson is at that position that you're arguing is the custody position?
Officer Jackson is standing near the defendant.
That's the fact that you have. And what is it, Officer Wright? Is that the main officer? Where is he at that time?
He is standing in front of the defendant talking to her.
Okay. All right. All right, you may continue.
Okay.
Actually, you can't.
Okay.
You keep telling me that the Ninth Circuit is like an umbrella, it's over California, and so we follow that.
Yes.
I follow that all the time?
You follow that when the law applies?
I follow that when the law applies. Does Craighead contradict any of the Supreme Court cases?
No.
What if it did? What would be your answer to what do I follow?
I would follow the Supreme Court case.
Okay, and I'm glad you would follow. What should I follow? What would your argument be to me? Because I don't care what you should follow.
You should follow the Supreme Court case if it distinctly, and you should follow the Supreme Court case.
Okay, and if I ask you this question, who carries the burden in this case? What would your answer be to that? Is there a burden? Do you understand the question?
Yes.
Okay, who has the burden?
The prosecution has the burden to prove that beyond a reasonable doubt that Adrienne Vega was in the car and that she stopped and knew that she was in an accident, didn't stop.
Okay, good answer, wrong question,
Sorry.
bad question by the court. Who has the burden in this motion?
I do to prove to you that Adrienne Vega was in or the defense does to prove that Adrienne Vega was definitely in custody beyond a reasonable doubt.
And do you have any other burden besides custody?
Not that I am aware of.
What happens to interrogation?
I assume that interrogation was a part of during custody.
Assuming in the law is very dangerous. It's two tests, right? You have to prove custody and you have to prove interrogation. If you just prove it custody, that's fine, but she didn't make a statement because there was no interrogation. Agree with me?
I understand.
All right. Who has the burden on interrogation?
I do.
Okay. All right. Continue.
So Miss Adrienne Vega was also being interrogated as if you compare her interrogation to that of Tony's, both were suspects and both were...
Stop for a moment. Interrogation. How are you using that word?
I'm using it as outlined in Berkmer versus Beckwith versus U.S.
Where did Beckwith come from? What court?
Beckwith comes from the federal court, Supreme Court.
Guessing or telling me?
Guessing. At that point, I'm sorry, sir, I do not know.
All right, don't guess. All right, do you know what year?
I do not know, sir.
All right, that's a better answer than guessing, believe it or not. Judges appreciate that when that happens. I don't appreciate that when that lady says it, but I appreciate it when you say it, okay? All right, so tell me then, I asked you about interrogation and what you meant by that, and you said Berkmer, right?
Yeah.
Okay, or Beckwith. So tell me why. What is that? What does Beckwith say interrogation is?
It outlines interrogation as words or statements that the police believe have a reasonable chance of eliciting an incriminating response from the suspect.
All right. Why in this situation are you using the word interrogation when you're talking about your client?
Because
using what you just told me.
Because they said they told her that they thought they outright told her that they thought she did it. And that